Welcome to Marshal Myths, presented by the United States Marshals Museum. I am David Kennedy, Museum Curator. In this episode, I will talk about the Judiciary Act of 1789. This falls under the status of point of fact. The Judiciary Act of 1789 is quietly one of the most important documents in our nation's history. The Founding Fathers recognized that one of the reasons for the failures of the Articles of Confederation was it had no clear means by which to adjudicate issues between the states, residents of those states, or even enforcement of criminal acts that exceeded the authority of any individual state. This derived in part from no mention of a federal judiciary, much less any form of federal law enforcement. This issue was rectified in part with Article 3 of the United States Constitution as ratified in 1789. Article 3 created a Supreme Court and established the jurisdiction and authorization of the courts to interpret and enforce law. Knowing that more work needed to be done, the Constitution gave Congress the power to create lower courts. The big question remained how to proceed. Spring 1789 saw the seating of the first United States Congress. The United States Senate was seated for the first time on March 4th. Given the nature of communication and travel in the 1700s, it took until April 6th for quorum to be reached. On that day, Congress certified George Washington as the first President of the United States. The next day, as one of the first acts of the Senate, a committee was assigned to bring in a bill for organizing the Judiciary of the United States. This committee had members from both the pro- and anti-administration factions, later known as the Federalist and the Democratic Republican parties. On the committee were a signer of the Declaration of Independence, members of the Constitutional Congress, veterans of the Revolution, statesmen, farmers, lawyers, a pastor, future federal judges, future governors, and even one member who was later in the House of Representatives. Their work was cut out for them. After the Senate achieved quorum and appointed the committee assigned to this task took 2 months to produce what would be the first bill which originated in the Senate. Over the course of the following month, the Senate continued through the readings and making amendments as needed before sending the bill on to the House of Representatives. The House read, amended, and approved the Senate bill over the next 2 months, while working through many other bills concurrently. The Senate received the amended bill a few days later. President Washington signed the bill into law later that week. The following day, he made the first appointments authorized by that law, among them the first United States Marshals. The Judiciary Act of 1789 did a few important things, in addition to creating the various districts and the positions of U.S. Attorney and U.S. Marshal. It also established the concept that the federal courts can overrule state courts. Some outstanding facts about the Judiciary Act of 1789. Not only was it the first Senate bill, but it was also the only Senate-originated bill of the first session of Congress. It was also one of the larger bills passed during the first session. The one bill which surpassed it in size consisted in large part of the geographic descriptions of the nation's port districts for the purpose of collecting duties. During the 4 months of debate in the Senate and the House, interspersed with other bills passed back and forth, not to mention during the development of the new country, discussion of the Constitution, and development of what would become the Bill of Rights. Of the 37 sections in the Judiciary Act of 1789, 5 specifically related to the office of Marshal. Section 6 gave marshals the power to adjourn courts if no judges are present. Section 27 is the real job description. It describes the 4-year term of the marshal, how to remove a marshal, the duties of the job, the ability to appoint deputies or otherwise command all necessary assistance, and the oath for the office of United States Marshal. Section 28 deals with how to replace a marshal and how to deal with a marshal who is directly involved in court process. Section 29 gives instruction as to how obtaining and seating jurors should proceed. Section 33 states that marshals have duty to transfer prisoners to the appropriate federal district, a responsibility still held today. Thank you for taking the time to learn about the Judiciary Act of 1789. If you have a question about this video or have a marshal myth you would like explored, please contact the museum by following the links below. Thank you for watching.